Today's appeal involves Bradshaw Development, the owner of Anytime Fitness, and its alleged violation of Washington state COVID-19 restrictions during Phase 1 of the reopening plan issued in May of 2020. During Phase 1, only essential businesses were allowed to operate while fitness centers were required to remain closed. Despite being notified by Washington Department of Labor and Industries through a cease and desist letter, Bradshaw Development continued operations. On June 15th of 2020, department inspectors visited the facility. Upon their arrival, the inspectors observed a lit neon open sign on the facility's building. They called the phone number on the door, but nobody answered. The two inspectors watched an individual wearing gym clothes and carrying a gym bag employ a keycard to unlock the front door. One of the inspectors grabbed the door before it closed, and both inspectors entered. They saw 3 people in the office, 2 employees, and 1 potential new customer, as well as 10 individuals using gym equipment. When they identified themselves and requested permission to search the premise, an employee denied consent but asked them to wait for the general manager, Jeff Mercer. While waiting, the inspector saw more people entering the gym and noticed a chalkboard sign near the entrance that read "Welcome back." When general manager Jeff Mercer arrived, DLI inspectors presented their credentials and requested to search the gym. Mercer refused, citing it as private property. The discussion moved outside to public property, where Mercer dismissed the Emergency Proclamation as a joke and claimed that the inspectors were violating the Constitution. He insisted the gym would not close. On June 25th of 2020, DLI issued a citation against Bradshaw Development for operating this Anytime Fitness, along with citations for violations at 3 other locations. Now, Bradshaw Developments is appealing the previous decisions, arguing the department did not have the legal authority to follow a gym member through a locked door into the fitness facility, and they are requesting further considerations of the Fourth Amendment protections. Let's take a look.
May it please the court, I appreciate you hearing this matter. Originally, apparently it was scheduled not for oral argument. We have it now for oral argument. This is a case that's nearly 5 years old. It started in June 15th, 2020. There were 2 citations originally, one from June 15th, 2020, and then 3 alleged incidents, violations from July 15th of 2020. And so those resulted in 2 citations. There's 1 remaining citation right now. Excuse me?
Mr. Brumback,
Yes,
I may
Judge.
interfere in your desire to finish your presentation within 10 minutes. I have some questions for you. Was Anytime Fitness SELA facility open for business on June 15, 2020?
There was an open sign. I think that was part of the evidence, and I'm going with what the evidence was, Your Honor. And there was evidence of a person, an unknown person, entering with a key card. So in terms of the indicia of the business being open, I think both parties are probably aware and cognizant of that evidence. There is the issue, but yes.
If Anytime Fitness SELA facility was open for business on June 15, does that mean it was open to the public?
No, Your Honor. It's a locked door.
Why not? Because of the locked door. Does the Peters decision stand for the proposition that an area reserved for a limited group of individuals may still be an area open to the public?
Great question, Judge, and that's exactly what I was going to deal with, that in the Dodge City case that was cited in the materials by the state. The Peters case absolutely does not apply. And I'll give you the distinction, Judge, because that road going into the RV park that the court relied on as sort of in its analysis of whether or not inspectors could go there. Imagine if that road had a swinging gate that was locked. That's analogous to this case here. That was an open road, and that's a major difference. So in this case with Anytime Fitness, and we know it's Anytime Fitness, a 24/7 fitness facility, were there employees there or not? 24/7. We know from the Board of Industrial Insurance Appeals panel judges, they cited and referenced, as I have all along, 4 things that need to be done that the state must prove. by a preponderance of evidence, a cited standard, the requirements of the standard were not met, that employees were exposed to or had access to the violative condition, and the employer knew or through the exercise of reasonable diligence could have known of the violative condition. They can't prove any of those with the record that we have. And this is exactly why I rested when I was at the hearing, because I knew as a prosecutor and a former defense attorney and so forth, just an attorney who does trial practice, that they didn't prove their case. They didn't. They didn't prove their case. They didn't prove the presence of any employees. Now, to me, the most troubling aspect of this case is that the state inspectors felt that they could sneak into my client's business. And that's what they did. They tailgated. They went through a secured door, a locked door. Doors are locked for a reason. That means that a person's not to go into them unless they have permission. And
are they locked? Are the doors locked for the purposes of excluding labor and industries inspectors?
Well, they're locked, Your Honor, for safety. You can imagine a nurse getting off from a hospital at 3 in the morning and wants to go work out. They don't need to have people going in and out of that place.
For safety, it would seem then that it's not locked for labor and industries inspectors because they're concerned about safety.
They may have a concern about safety, Your Honor, but they need to have permission to do an inspection. The law is absolutely clear. 49-17-070 is clear on that. And then the next section is absolutely crystal clear that if they don't have permission to enter, they need to get a warrant. And
do you find any case that addressed an administrative search inside a key lock facility or a key card facility?
A key card facility specifically? No, Your Honor.
Were individuals permitted to enter the facility on June 15 to sign up for new memberships?
Your Honor, the record is devoid of any information about that. And part of the reason it's devoid is because the state did zero discovery. And that was referenced in the panel judge's decision and order again, that they didn't get any business records. They took no depositions. They didn't do any requests for admissions or any of the things that could have developed that aspect of the record. So
that the inspectors testified that there were individuals signing up for new memberships inside the office.
Well, that's it. That's a speculative conclusion that has no basis in evidence. They saw people inside. Do they know if they were family members, friends, people who were off duty, people who were former employees? Maybe it was somebody who was working out that was friends of the owner. We don't know any of that because they didn't develop it. We don't know any of the names, the ages. Is it somebody who was maybe an employee, but who was not on the clock? Those are all pertinent questions that are the burden of the state to prove. And we just don't have a record for that, Your Honor.
Was Mr. Mercer working at the time on June 15 when he spoke to the inspectors?
Your Honor, he was summoned to that location. And my understanding from the record, and it's a scant record that was developed by the state, that he met them outside. And so he was outside the facility when he was talking with the inspectors.
Was there some person that he or she needed to get a hold of the manager, Mr. Mercer, to determine if consent was going to be given?
Your Honor, I don't know exactly how that happened. I know that the inspectors, when they were encountered the locked door and could not enter for the purposes of gaining permission to enter, they had a number. I don't know if that's the same number that Mr. Mercer had. And certainly I don't want to transform myself into a witness at all in terms of what the evidence is on this. And I think that's the reason Judge Strange vacated or dismissed all of these citations. It just wasn't a very developed evidentiary record, Your Honor, for them to find it.
Mr. Brumback indicated that it's speculation as to whether some individuals inside the facility were applying for membership. But my original question was, could a member of the public go into the facility on June 15 to sign up for a new membership?
Your Honor, I don't want to be flippant about it, but there's no evidence about it. I suppose they could do the same thing that the inspectors did in tailgate and gain improper or unauthorized permit or entry. But in terms of how that, I personally don't know, and the record certainly wasn't developed in that regard.
Is a fitness facility more susceptible to the spread of the Corona-19 virus than other facilities?
No, Your Honor. I mean, again, I'm no expert, but certainly the governor's orders allowed places that sold cigarettes, booze, and marijuana to be open as essential, but a healthcare facility. Now, if you do look at the record, the certified appeal board record, I did have a witness that was going to testify to that effect, that health clubs or gyms were facilitating fitness, and that was going to be part of my approach on this case. Unfortunately, the state, when it rested, just didn't have a prima facie support in terms of the evidence to get a conviction or to find a committed violation on any of the citations. So I rested on that. But it is part of the record. It's just wasn't admitted at the hearing. So, but
were Anytime Fitness customers told by Anytime Fitness not to allow someone to tailgate himself or herself into the facility?
Were they told not to allow somebody to tailgate? Well, I think that is presumed by the fact that the door is locked, Your Honor. That if tailgating was permitted, why would they lock the door?
My question, though, was, is there any evidence that the customers were told not to allow tailgating?
I got you, Your Honor. You're correct. I don't know of any evidence that's in the record with regard to that.
Okay, I still have questions, but we'll rest for a minute. Thank you, Mr. Brumback.
Yes, Your Honor. Thank you. And then I think everyone probably gets the gist of including my materials.
Your name, you're the former Yakima County elected prosecutor, correct?
No, Your Honor, that was my partner, Joe Brusick. I'm his partner, former partner. Okay. Yes, Your Honor.
The BRU partnership.
Yes, Your Honor, that is correct.
All right. Good morning, Ms. Sandstrom. You may proceed.
May it please the court, I'm Anastasia Sandstrom, Assistant Attorney General representing the Department of Labor and Industries. Illinois' enforcement of important safety rules should not be hindered, and the board's decision should be affirmed for 3 reasons. First, the board's finding that the business door was a reasonable, recognizable entry point is supported by substantial evidence. Second, RCW 12070 allows testimony of an inspector if the violation is in open view, and substantial evidence supports the finding was in open view. Third, there's no 14th Amendment violation when the action was done in the presence of third parties, and substantial evidence supports it was done in the presence of gym members. I would first like to...
Go ahead. My only question is, when it's a reasonable point of entry and it's locked, wouldn't the remedy be to knock rather than tailgate?
Well, they did try to call. There was a phone there, so they tried to call to come in.
Would plan B be to knock after you see someone enter?
The record doesn't say whether they knocked or not, but someone came in with a gym bag and didn't say don't come in, or there's no evidence of that. And the statute allows entry in a reasonable recognized entry point without delay. And the statute provides that you can go through that in order to seek consent, which is what they did. And that's the process. You don't need permission to enter initially if you enter a reasonably recognizable entry point, and then you need permission.
Ms. Sandstrom, is a reasonably recognized entry point, is it an exception to the warrant requirement? Does it give Department of License or Department of Labor and Industries the ability to go into an otherwise restricted area?
Well, there's two different issues here. There's and the constitutional issue. With respect to the statutory issue, the statute is allowed, the legislature is allowed to have entry statutes and say that you have to have consent, but that you can enter in a reasonably recognizable entry point to gain consent. And the statute allows that. Under the 14th Amendment, there's no search because they were allowed to come in under the statute, and there were third-party precedents. This is not an area that's restricted to everyone. Under the Peters case, if you have third parties present, then it's not a Fourth Amendment violation. And I would note that the Katz decision, the Supreme Court decision, says that the presence of outsiders means that it's not a reasonable assertion of privacy. They may have the subjective assertion of privacy by the locked door, but there wasn't a reasonable assertion of privacy because they allowed the third-party gym members. And if the third-party gym members could witness the violation, so could the inspectors.
So your reading of Peters is if there's a third-party person there, then even if it's locked, they can come in?
Well, it's of Peters and of many cases. The department cited many cases that provided the proposition that for have a reasonable expectation of privacy, it's not a search if there's third party present. And in Peters, there was a no trespassing sign, but they allowed the RV people to be in there. So when you have that contradictory information that third parties can be present, then it's not a search under the 14th Amendment.
Ms. Sandstrom, if let's say they hadn't tailgated in, could they have broken the lock and come in?
Well, I think that you look at the statute and it says that you look at the statute and it says that you have to enter in a safe manner at a reasonably recognizable
so there would be no safety
so that means
concern.
It has to be reasonable. Oh, sorry.
They're just going to punch the lock and walk in.
But that's not reasonable.
Why?
Because that's destroying property and that's not in a safe manner. It wouldn't be
safe. What if they could pick the lock then? Or maybe they knew the code and they punched in the code and walked in. Could they come in?
Well, then you have to look to the statute. And if it's a reasonably recognizable entry point, you can go in and then obtain consent.
Even if it's locked.
Well, yes, because the statute says trespass, or the case law says trespass isn't a bar to a Fourth Amendment, doesn't create a Fourth Amendment issue. That's in the Peterson case. So trespass is a separate issue, and the case law under Peters is that you can trespass government if it's allowed by statute. So the statute allows entry at a reasonably recognizable entry point, and it shall be safe. And this is just a fact question. The reasonableness of it is not without bounds. It's up to the Board of Industrial Insurance Appeals to find whether it was reasonable enough, and it did on these facts. There was no breaking of anything.
So, Ms. Sandstrom, could law enforcement do what DLI did?
Well, I don't think that they're subject to RCW 49-17070.
So they couldn't.
Well, I don't know if they have a separate statute that enables them, but they're not authorized under RCW 49-17070.
And you're saying that 070 creates an exception to the warrant requirement?
Well, again, there's two different requirements. There's no requirement for a warrant if you enter at a reasonably recognizable entry point that's safe, and that's a factual issue for the judge. So if you enter in that manner, then you have to then you obtain consent. That's the order. Otherwise, the department would never be able to inspect if there's a door shut.
Ms.
Unless
Sandstrom,
we
is
get a
there a
warrant.
requirement to maintain a reasonably recognizable point of entry?
Pardon me, I didn't hear the question.
Is there a requirement that a business maintain a reasonably recognizable point of entry?
Well, there is a requirement that you allow your facility to be inspected. Washington Industrial Safety Law is there to protect workers. You look at legislative intent to protect workers. That is construed for safety, and that provides for the statute that allows for entry in order to seek consent. And that's the order of events. The legislature's authorized to have such a procedure, and if consent is denied, then the warrant kicks in. So that's under the statute. The Fourth Amendment requirement of a warrant is not triggered here because the presence of third parties. And the department cited many cases besides Peterson for the purpose of showing a reasonable entry. There's one case, Hastings, where it was the business transactions were illegal and the presence of third parties said that it wasn't a reasonable expectation of privacy. I would like
Ms. Sandstrom, you indicated that the question of the reasonable expectation of privacy, I believe, was a finding of fact by the board. Is that correct?
No, that it was a reasonably recognizable entry point was a finding by the board, that it was reasonable.
And is that a finding of fact that we defer to?
Yes, this is the substantial evidence standard of review applies under RCW 49-17-150, and as substantial evidence is that you defer to that finding about a reasonably reliable entry point as a matter of an element under a statute that's within the jurisdiction of the board to judge.
Does that finding implicate the Constitution and constitutional requirements? And if so, do we defer to findings that have constitutional implications?
Well, the constitutional implications here are whether it was reasonable. I don't know that it's constitutional whether it was reasonable to enter. I think that's a statutory concern. But whether the business was open and whether third parties were present are also factual issues that the court has said are judged as a matter of fact. And the fact finder here was not the Superior Court, and it's not the Court of Appeals, it was the Board of Industrial Insurance Appeals. So the board said it was open, that there were employees present, that's supported by substantial evidence, and there's no assignment of error on that finding. There's no assignment of error on these findings. And that it was reasonable to enter is a finding, and that there was the presence of third parties is a finding. All of that under constitutional law has to be determined by a fact finder. The Superior Court is not a fact finder. There is no argument by Bradshaw that it had to be the Superior Court that was somehow involved in that process. The understanding and argument was it was the board's decision that was being reviewed for factual issues.
You mentioned there's a statute that requires a business to allow access to Department of Labor and Industry agents for inspection. Can you cite that number, please?
Well, the statute that provides that allows L&I inspection is 49-17-070, but it requires consent. But in order to gain consent, first you can enter in a reasonably recognizable entry point that's safe in a safe manner. Once you've accomplished that, then you have to directly go and ask for consent. But while you're there to seek consent, the constitutional provisions under subsection 4 of open view.
I'm aware of that statute. I thought you were citing a different statute that imposed some duty to allow access. What were the third parties that you are referring to as making the area open to the public?
Well, the board found that there were employees present and that there were gym members present. And the gym members are the third parties. And that's a factual determination that's supported by substantial evidence. I mean, you see someone
Did
coming
the
in.
board find there were members of the public applying for membership?
The board did find that.
RCW 49170701A authorizes Department of Labor and Industry agents to, quotes, enter without delay, close quotes, a workplace. What does the phrase without delay add to the statute?
I think what it does is it shows the importance of inspections by labor and industries. And I think perhaps I should step back and say that that does provide for the legislature's understanding that employers will allow without delay the ability to at least seek consent. So it sets up a system where investigations are critically important for safety for workers in order to stop dangerous circumstances, and that has to be done without delay.
Okay, the second sentence of RCW 491707 subsection 3 reads, solely for the purpose of requesting the consent required by this section, the DLI agent shall, in a safe manner, enter a workplace at an entry point. Does this statute mean that the sole purpose for going inside is to gain consent, and that if the L&I agents do something else, that's not authorized by the statute?
Well, that statute does provide you enter to gain consent. However, it is clarified by subsection 4 of the statute that this section does not prohibit the director or his or her authorized representative from taking action consistent with a recognized exception to the warrant requirements of the federal and state constitution. So that allows for circumstances.
Okay, I want to ask you questions about that language. What does taking action mean in this context?
I think taking action can mean testifying in court or at the board.
Well, let me suggest a different interpretation, that it means taking some affirmative action rather than just staying still observing what's happening inside. And I'll quote to you the definition of take action in Merriam-Webster's. It's to do something, to act in order to get a particular result. And I'm wondering if taking action means something like quickly entering the premises because there's exigent circumstances, and it does not apply to passive conduct such as just standing there observing what's happening.
I see my time is almost up. May I answer the question?
Yes, please. Thank you.
Yes, please. And we'll have some other questions.
Well, I think that seeing is active. That's taking action, looking, keeping your eyes open. And that's consistent with the open view doctrine or the plain view doctrine. And there's nothing in the statute that is said to circumscribe the LNI's ability to use the state and federal constitutions in order to promote worker safety. Distinguishing it by the fact that they weren't acting in an exigent circumstance would read out the language of the statute, which allows open and plain view under the federal and state constitution. The department...
The statute doesn't specifically mention open and plain view, does it?
No, it says recognized exceptions to the warrant requirements of the federal and state constitution. And I don't think anyone disputes that open or plain view are recognized exceptions.
Did the department argue that the inspector standing outside the facility knew that there was a violation because of the open sign and the customers going inside, and because of that, inevitably workers were inside?
There was no testimony as to that. But there didn't need to be, because the statute allows entry in order to see and gain consent in order to inspect, and the statute subsection 4 allows for the open view doctrine and plain view doctrine and does not require inspectors to close their eyes. They can actively look as they walk to get consent.
Did the department argue before the ALJ and the board that the person who denied consent and said, "I'll go get the manager for you," was in fact a worker at that time inside the building?
Well, that's in the board's decision that they considered that person to be a staff person. That's the board.
Okay.
The board.
Thank you. That's all my questions, Chief.
Thank you. The department asks that this court reverse the Superior Court and affirm the board. Thank you.
Thank you. Mr. Brumback, do you have any rebuttal?
I have questions for you,
Yes,
Mr. Brumback.
Yes, Your Honor.
Anybody in the panel want to ask some questions before I go?
No, go ahead.
Does Bradshaw Development contend that RCW 4917-070 is unconstitutional?
Not unconstitutional, Your Honor, misapplied. I mean, you referenced the word solely, which I think is an important word. What the state, the AG's office is trying to do is render that word null and void, because they did more than that. They obviously did an inspection. They never did open an inspection, technically an actual inspection, yet they did an inspection because they didn't limit themselves to solely. They walked in and they were full eyes on doing exactly what an inspection is and looking around and in there when they weren't supposed to be in there. This is all about a locked door. If that door wasn't locked, then we have a completely different situation here. They could have entered in and asked for permission to do an inspection, and then the owners or the staff member or a manager or somebody could have said no, and then they would have had to go get a warrant, but they would have been limited entirely in their scope to just inquiring about permission to inspect. Nothing else. So in that regard, it's not that it's unconstitutional in terms of that statute. It's just limited in scope with regard to what the state powers are in this context.
The board found that tailgating and entering the door was done was a reasonable access point. Do we defer to the board on that finding?
Your Honor, I believe that I'm sorry, did somebody chime in? I heard a little. Okay. So this term reasonable access point, a door, sure, that's a reasonable access point. Unfortunately, the law, the statutory law that's applying here doesn't distinguish between a locked door and an open door. So yeah, if it's unlocked, then it's reasonable to go through that access point. But if it's unlocked, I should have said, if it's locked, then it is still a reasonable access point. But in its present configuration, you're not able to go through it without permission. In fact, if we look at that subsection 3 of 4917-070, it says that the inspector shall obtain consent from the owner, manager, operator, or his on-site person in charge of the work site when entering any work site. So that, there's as often is the case with written law, it's hard to apply it to every situation. In this situation, we have a locked door. So they weren't able to get permission when, not after, not before, when entering. That's what the statute says. So what do they do? What's their alternative? They go get a warrant. In the next section, 075, is pretty clear. Go get a warrant. They never did get a warrant. And they never did get permission to enter to do an inspection. So they didn't follow the law. And what the state is asking us, I'm sorry.
Any party introduce a diagram of the facility into evidence?
I didn't put evidence on, Your Honor, and the state certainly did not do that. And like I said, no discovery was ever done by the state prior to this hearing.
Chief, that's all my questions. Thank you.
Thank you, Your Honor.
Mr. Brumback, did you want to wrap up anything?
I think the issues are well understood, and I appreciate your time, Your Honors. Thank you very much.
All right, counsel, this matter is being submitted.
Following these arguments, the court concluded that tailgating behind a gym goer with a key card to gain access constituted an unreasonable point of entry and violated the fitness club owner's reasonable expectation of privacy. As such, the court affirmed the Superior Court's dismissal of the citation against Bradshaw Development for violating the COVID restriction. Do you agree with this finding? Please let me know what you think about the 2020 restriction enforcement actions. And if you like this video, please hit subscribe for new arguments every week.